and welcome to today's PMA California District webinar titled New Regulatory Issues Impacting California and How to Comply. Today's webinar will be presented by Terry Montoya and Ted Bacon, partners at PMA member company Frost Brown Todd, a full-service law firm with more than 575 lawyers operating in 16 offices across 8 states and Washington, D.C. As a member of FBT's Environmental Practice Group, Terry Montoya helps clients resolve air, soil, and groundwater disputes. He has significant experience litigating claims under numerous state and federal environmental statutes and common law. Ted Bacon is a partner in charge of Frost Brown Todd's San Francisco office, helping clients understand, navigate, and resolve complex employment and business disputes. He advises clients on a broad spectrum of issues, ranging from counseling on day-to-day matters to handling full-on jury trials. It is my pleasure to introduce our first speaker, Terry Montoya. Terry, take it away.
Well, good morning, everybody. In your virtual rooms, hope you're comfortable and have better snacks than I do. I want to quickly thank Randy and Aaron at PMA for inviting Ted and I, and for Molly Johnson at Frost Brown Todd, who's going to be handling the slides. So, thank you all. Let's get into it. If we can advance to the next slide. Thank you. So first, we're going to talk about California Senate Bill 253 and 261, part of the Climate Corporate Data Accountability Act. And then we're going to transition to the South Coast AQMD's WAIRE program, warehousing rule. So first things first, on September 12th, the California Senate passed Senate Bill 253, the Climate Corporate Data Accountability Act, and Senate Bill 261, the Climate-Related Financial Risk Act. Governor Gavin Newsom signed these bills into law on October 7th. These are the nation's first greenhouse gas reporting and climate disclosure bills that merit careful attention by businesses at all levels, and I'll explain what I mean by that in a minute. Public greenhouse gas emission disclosures are part of California's overall effort to reduce greenhouse gas emissions as part of Assembly Bill 32, the Climate Change Scoping Plan. Essentially, California's goal is to get to the point of being carbon neutral by 2040. And, you know, the background story of Senate Bill 253 and 261 is that California wants to identify those companies doing business in California and make sure that they make public their concern about meeting the greenhouse gas emission requirements in specific manners. And we'll talk about those in just a second. So Senate Bill 253, that'll require U.S. businesses, and that's U.S. businesses in the broadest sense, corporation, limited liability companies, partnerships, with annual revenues of over $1 billion that, quote, do business in California, end of quote. We'll talk about that. That's why it's in quotes. To report annually on their greenhouse gas emissions. Senate Bill 253 is expected to apply directly to approximately 5,000 companies doing business in California, and indirectly to thousands more. Now, some of you in the room are saying, I'm not going to pay any attention because Terry's talking about annual revenues of $1 billion, and I would love to have annual revenues of $1 billion, but I don't. You do have to pay attention because indirectly, if you're doing business with a company that has to report under Senate Bill 253, they will ask you to provide them your greenhouse gas emission data, which is part of their reporting requirement. So we'll explain all that in a second. Likely many of you in this webinar provide goods and services to companies that fall under the ambit of Senate Bill 253's financial threshold. So that's why we're talking about this very timely and reporting heavy obligation. Next slide, please. Thank you. Senate Bill 261 will require U.S. businesses, again in the broadest sense, with annual revenues of over $500 million that do business in California, to publish climate-related financial risks in biennial reports. Senate Bill 261 is expected to apply to approximately 10,000 companies and more indirectly. Next slide, if you would. Okay. Senate Bill 253 will require the reporting of Scope 1, Scope 2, and Scope 3 greenhouse gas emissions, regardless of the location of the emissions. Many public companies already track and report greenhouse gas emissions, but Senate Bill 253 will also affect other companies, and that's where you guys come in. Indirectly involved and also obligated to report the greenhouse gas emissions to their client, your client that has the full obligation within the supply chain of a Senate Bill 253 compliant company that must report its controversial Scope 3 and greenhouse gas emissions. First, let's consider what doing business in California means. So let's presume you in the virtual audience or Senate Bill 253 compliant company, if you are or if you're not, you want to argue that you're not doing business in California because, for instance, your business is located out of state and you're shipping a product or material to a California entity that is subject to Senate Bill 253. Or suppose you in the audience, although not within Senate Bill 253's 1 billion in annual revenue definition, you're working with a company, your client that is subject to Senate Bill 253, but only have a shipping facility in California that takes out-of-state products and sends them to their final delivery point. So if you're just shipping product, some kind of material, some component to a business that is compliant, is it all their problem because you're not doing business in California? I doubt that's going to work as an argument. Senate Bill 253 does not define the term doing business in California, but it relies on other California statutes that define the term quite broadly. For example, the California Corporation Code. Under that section, a company does business in California by entering into repeated and successive transactions of its business in the state other than interstate or foreign commerce. So essentially, you got a footprint in the state and you've been doing more than one transaction. You're doing business in California. And if your client who has to report Senate Bill 253 greenhouse gas emissions tell you to do it, you're not going to wriggle out of it by claiming you're not doing business in California. There's another definition that's even a tighter noose around businesses that want to make this defense. The California Revenue and Taxation Code defines doing business as actively engaging in any transaction for the purpose of financial or pecuniary gain or profit. That's a broad net designed to ensnare businesses that have any sort of California footprint under the "you're doing business here" requirement, leaving little if no room to free yourself. I presently have a client, international client, cabling and wiring, and they only have one delivery facility in California, just one, but they meet the $1 billion in annual revenue. They're on the hook for Scope 1, Scope 2, and Scope 3 greenhouse gas emission reporting, because even though their one facility takes in product from various sources and then distributes it to customers, that clearly falls under the definition of the California Tax and Revenue Code of actively engaging in a transaction for the just to get profit. So while SB 253 does not define doing business in California, the AQMD is working on its final version of all the rules. They're likely, in my opinion, to select the California taxation code definition of doing business in California. So that's not going to be a viable way to get out of compliance with Senate Bill 253. Essentially, as Governor Newsom has publicly stated, if you have a presence in California, we want you to make clear to the public that you're on board with our aggressive goals of being carbon neutral. And if you're not, we also want you to make that clear to the public, and, you know, your business might suffer. So footprint here, doing business here, footprint out of California state, shipping product into California to someone who has to comply, still gets you into the same we're doing business in California net. So now let's explain what Scope 1, Scope 2, and Scope 3 greenhouse gas reporting requirements mean. So Senate bill requires the reporting of Scope 1, Scope 2, and Scope 3 greenhouse gas emissions. Senate Bill 261 only requires a company to report its Scope 1 and Scope 2 emissions, not Scope 3. So we're talking about the bigger reporting obligation here. Many public companies already track and report on greenhouse gas emissions because if you're doing business, for instance, internationally, that reporting is commonplace. So Scope 1 emissions, they're defined as all direct greenhouse gas emissions that a company owns or operates regardless of location. So your Scope 1 emissions are for every single facility that you have. You have to report greenhouse gas emissions. That means the emissions from company vehicles. And company vehicles is in the very, very broadest sense. Forklifts are company vehicles, and forklifts, you know, they put out for their size and weight, they put out a tremendous amount of you know, carbon dioxide and nitrous oxide emissions. So all forklifts, all company-owned vehicles, all delivery vehicles coming in, idling on the site, how long are they idling, and going out. All of your equipment. Do you have machinery on the site? The machinery, the manufacturing equipment will be able to give you a greenhouse gas emission estimation as to what in terms of greenhouse gas emissions that particular machinery puts out. Air conditioning compressors, heating elements, you know, everything that when you turn on the switch in your facility, unless you're using hand tools and horse-drawn carts, are likely to have some greenhouse gas emission component. So you have to cobble all those together, and some of those, the manufacturing entities of the products themselves will tell you what the greenhouse gas emission are from that vehicle, and put those in the Scope 1 category. Scope 2 emissions are defined as all indirect greenhouse gas emissions from consumed electricity, steam, heating, or cooling purchased from from an outside entity, a reporting entity. So Southern California Edison will be able to give you its greenhouse gas numbers that you'll put under the Scope 2 category. And cooling equipment, that's probably likely going to be in your scope 1. And steam heating, that also might be more likely in your scope 1. So scope 2 is likely to be power that you acquire from an outside entity. The most controversial and difficult greenhouse gas emissions to track and to report are what's known under the scope 3 emission definition. That definition includes all indirect upstream and downstream greenhouse gas emissions other than scope 2 from sources that you don't own or directly control. So essentially, it is your entire supply chain. If you're a company that has to comply with Senate Bill 253 and you deal with several types of other companies, suppliers, manufacturing entities in the United States, in California, outside of the United States, you have to go to those entities and you have to say, I fall under the scope 3 obligation. So all of your greenhouse gas emissions, you have to give to me so that I put them in the scope 3 category, probably under your name. You know, I do business with this contractor. So if you're supplying metal parts to a company that's obligated to report scope 3, where did you get your metal? Do you deal with a supplier, or do you deal with an international company, with a mine directly? For instance, like my client gets a lot of its copper from African mining sources, so they have to, and we're not entirely sure how that's going to be prepared, but they have to go to the mine and they have to say, okay, what are all of your greenhouse gas emissions? And then when the product gets on a ship, we have to calculate the greenhouse gas emissions for the shipping company, for the travel to a waylay point, that particular point, which is storing it, and then transitioning to another supply chain activity. Each one of those components, the greenhouse gas emissions have to be calculated and reported on. It's an obligation to track and report under the SB 253 compliant company's climate impact across its entire global and domestic operations, arguably the entire supply chain. California's Air Resources Control Board will then verify all the submitted data, given its experience in carbon accounting, and your data, before you turn it in, may also have to be reviewed by an accounting reporting agency to verify its accuracy, because there's some benefits to, if you're giving this data to someone else, to corroborating it first, because at the very end, the Senate Bill 253 compliant company is going to have to certify to the state government that everything's accurate. So if you're a supplier to them, you want representation to make sure that they're not pushing too much responsibility and penalty exposure to you. You're a small piece of something much, much larger. You want to limit your liability. So right now, Senate Bill 253 companies have to report their scope 1 and scope 2 greenhouse gas emissions beginning in 2026, and their entire scope 3 emissions in 2027. Senate Bill 261 requires annual submittal of climate-related effects and mitigation measures in their first report, which is due January 1, 2026. Now, the scope 3 obligations are still, the rules for those are still being considered by the AQMD. They haven't yet issued their final rules, and they have an initial date of the end of 2025 to get those rules out, that's exceedingly aggressive in my opinion. So for now, under 253, 261, everyone's got to report scope 1 and scope 2 pursuant to their schedule. There's a question mark there as to how the AQMD is going to define what's scope 3 emissions, and it's probably not going to be all done in time to report on 2027. There's a further wrinkle. There is a legal challenge that's just been filed to 253. So what does that mean in terms of reporting? So there's a federal lawsuit that was filed in California's Central District by California Chambers of Commerce and the American Farm Bureau. And their lawsuit, it's just a lawsuit now. So it's just allegations. They haven't been deemed legal and they haven't been tried to determine their veracity. But the challengers at this point want to enjoin, which means to stop the enforcement of 253, and to ultimately declare 253 to be unconstitutional under the United States Constitution, and therefore unenforceable under two arguments. And one I find more interesting and stronger than the other. But they're making, first of all, a First Amendment argument, saying that 253 is forcing businesses, compliant businesses, to engage in subjective discussions regarding with their subcontractors and their suppliers regarding what is greenhouse gases, what constitutes climate control policy concepts and risks. Essentially, boil it all down to something simpler. What they're saying is they're forcing them to get into these discussions which are not related to their business, not related to their profitability, and they're based on concepts that are vague and nebulous. And that's not what the First Amendment should force them to do. That's not what the state of California should force them to engage in terms of discussions, which violates the First Amendment. Interesting argument. We'll see how it goes. I don't have as much faith in that one. However, they're also alleging another constitutional argument, and this is the one that I've mentioned to my clients previously that would be, I think, the strongest argument. And that is California is seeking to regulate not only greenhouse gas emissions in its state, but as we've explained, throughout the United States and on a worldwide basis. And California does not really have the power to invoke scope 3 reporting across the United States. Let's just take the United States, because Senate Bill 253 is under the Federal Clean Air Act authority. And under the Federal Clean Air Act, only the federal government, only the EPA, and in California, it's the Cal EPA, they have the authority, the supremacy, the exclusive supremacy power to regulate intrastate greenhouse gas emissions, not California. So the result is that Senate Bill 253, if this argument is accepted, would represent an impermissible impacting of intrastate commerce, which is a violation of the Dormant Commerce Clause. That's where I've always felt Senate Bill 253 was weak. So, brand new complaint, hasn't been legally vetted out. So in the meantime, it does not stop the reporting obligations. So we still have to worry about that. We still have to take that seriously until there's a final ruling by a court. And this is something that's going to impact a lot of big companies. So I see it going, if these plaintiffs win, or other plaintiffs, there's probably going to be other lawsuits filed too. I see it going through federal appellate review and maybe even higher. So that's Senate Bill 253, 261. That's an explanation of what it is, what it means, and why you in the audience still need to worry about it, even though you may not fall under the definitions. So let's transition, if we can go to the WAIRE program. And let's go over to one more slide. I'll explain everything there. Perfect. Thank you. So South Coast Air Quality Management District implemented 2 years ago the WAIRE program, which seeks to reduce diesel emissions, particulate matter emissions, and nitrous oxide emissions from warehousing communities, warehousing sites. And, we all know that they've been popping up in geographically desirable areas. And it's not typically one warehouse, begets several others. So why in this slide is South Coast Air Quality Management District's Executive Officer Wayne Nastry telling companies in their press release, you've had plenty of time to take this seriously, and if you haven't, we're coming after you. Well, there's a couple reasons why. First of all, Southern California's geography. Southern California is rather unique in lots of ways, but in its geology, it has the Los Angeles Basin, the Orange County Basin, the larger basin. It has transverse mountain ranges that run east to west. So Santa Monica Mountains, for instance, come close to the ocean, and they run east to west, as do a couple others. And then they run into mountain ranges that run more traditionally north to south. In conjunction with the proximity of the ocean, which has heavier weight water because it's humid and it's wet, that sweeps onto the shore, it presents a big bowl where emissions, unclean air, carbon dioxide, particulate matter gets trapped within this bowl. It's trapped by the mountain ranges, the east-west and the north-south, and it's kept there by a marine layer. So Clean Air Act requirements in Southern California are ardently and strictly enforced because under the Clean Air Act, under this geologic situation, Southern California is not going to be close to meeting even the barest of Clean Air Act rules. The next factor is the concept of environmental justice, which is permeated all layers of environmental law. The EPA defines environmental justice as the fair treatment and meaningful involvement of all people, regardless of race, color, national origin, and income, with respect to the development, implementation, and enforcement of environmental laws. And this came out as a result of the disastrous publicity the Cal EPA entity, the Department of Toxic Substances Control, received over the Exide battery plant, where it really allowed Exide to pollute a community, a low-income community, with lead-impacted soil. So going back to Wayne's comment, Wayne is saying, look, communities near warehouses, which tend to be, below middle-class communities, they have the right to breathe clean air, and they've kind of been ignored for a long time. So we're coming after you. So that's one component of it. Next slide, please. Okay, the reporting requirements. Warehouse operators and owners are required to adhere to specific reporting obligations under the WAIRE program. These obligations include submitting an annual WAIRE report by the January 31st each year, documenting compliance actions taken in the previous year. So the program categorizes warehouses into phases based on their size, with different phases having specific deadlines for their initial reporting and subsequent compliance action. But here it is in a nutshell. if you own or operate a warehouse, that's 100,000 square feet. And we're going to talk about that definition because that's not as easy to define as you would think. You have to have already, if you haven't done it, you're late. In the South Coast, AQMD knows who you are. So we need to get you into compliance right away. You have to submit a warehouse owner's notification detailing your warehouse and location, detailing all of your tenants, and roughly stating what kind of business you're in, what kind of goods are you going to having in your warehouse. Second, after that, you have to submit an initial site information report. This is a one-time report per location, which may need to be updated if you relocate to a new warehouse. New warehouse starts the rules all over. And that report has to detail what you're doing in order to reduce your emissions from forklifts, from the numbers of diesel trucks, diesel engine trucks, refrigeration units on the trucks, from generators, from air conditioning units, and other types of stationary equipment that are putting out emissions. Essentially, gas powered units. You have to detail those in your initial warehouse owner's notification and initial site information report, and then you have to go into the WAIRE website and pick up WAIRE credits. So you have to show an active participation desire and credits to mitigate the amount of emissions that you're putting out from your vehicles. So next slide, if you would. So WAIRE points and acquisitions. That's a critical component of the WAIRE system, and it serves as a metric for compliance. Operators can earn WAIRE points through three main vehicles. One, completing actions from the WAIRE menu on the website. So you can, there are predefined ways where you can reduce your emissions and improve air quality associated with warehouse operations, rather. We'll talk about some examples, but it's, can you convert some machinery to electric engines rather than diesel engines? Are you being aggressive about reducing idling diesel engine time on your site? Basic things like that. You can also implement an approved custom WAIRE plan where you tell the AQMD what strategies you have for emission reductions. It's easier to just pick from the menu, in my opinion, but you can go on a custom basis. Or if the menu isn't going to work for you, and that would be an astonishing thing to say if you're a warehouse owner and operator. But if it isn't going to work for you, then you can just pay the AQMD money. Pay the money for your inability to reduce your emissions. Or you may have to acquire some WAIRE credits, but also in addition there too, because of the excessive volume of delivery trucks incoming and outcoming, you may still have to pay a mitigation fee over and above that. So the number of points that each warehouse earns is based on a formula that considers the number of truck trips associated with the warehouse, with larger trucks having higher point value. And if you accumulate more than required, you can bank those points for future years, or you can transfer them to other warehouse owners that can't accumulate enough points. So it's going to create a market where you can reduce your emissions, and someone that can't says, "Hey, buddy, I want to buy some of your points from you." And that's been done on the carbon front. Carbon trading has been a vibrant market for those who take it seriously and get going. Next slide. So examples of earning points, qualifying points: deploying electric trucks, installing solar panels, and participating in community benefit programs. A lot of points attributed to that because, again, environmental justice is an important concern. Next slide, if you would. All right, there's a notice of violation system with the AQMD. There always is. So enforcement actions, including notices of violation, are issued to businesses that fail to comply with WAIRE program's requirements, underscoring the program's commitment to reducing emissions and improving air quality in South Coast region. I've been representing businesses before the South Coast AQMD for over a decade, and their violations are stiff. So best to take it seriously. But that is not the only threat that warehouse owners and operators face. That's because environmental justice is such a hot issue that the federal EPA is considering, next slide, the federal EPA is considering adding the WAIRE rule as part of the Federal Clean Air Act. I've been doing environmental law since 1992, my friends in the virtual room. I have never seen a state Clean Water Act, a state water code violation being added to the federal component. So, but warehouse particulate matter in certain areas, like in the Rialto areas and the Fontana areas, when winds kick up, particulate matter emissions from warehouses is a big Clean Air Act enforcement concern. But again, environmental justice, doing more for lower socioeconomic companies is one of the reasons why the EPA director said we are adding, they're considering it, but they've gone down the road, far enough down the road to where I'm convinced it will be part of the Federal Clean Air Act, so that WAIRE can be enforced on the state level and WAIRE can be enforced by the federal EPA. And if you didn't think that was bad enough, here comes the bad news. The bad news is under the Federal Clean Air Act, they have a private attorney general provision, which means that private plaintiff groups, and in Southern California, in all of California, there are scores of them, and they're all lawyered up. They, as soon as the EPA adds the WAIRE rule to the Federal Clean Air Act, then private attorney generals, pick any group, pick the Sierra Club by example, but individuals as well as groups that are better funded like the Sierra Club will then be able to go through the publicly accessible WAIRE compliance documents, find a violation in terms of an underreporting of emissions, particulate matter, nitrous oxide emissions. They have to serve a notice to the federal government, to the South Coast AQMD, and to the party that violated, saying, you have 90 days to fix this or we're going to sue you. And if the government doesn't expressly say, oh, thank you for bringing this to our attention, private citizen plaintiff, we're going to take over, which they don't customarily do because they don't have that money and time to deal with every violation that comes up. Then on the 91st day, the private citizen can file a lawsuit in federal court and go after you for WAIRE violations. And the story does not get better, people, because if you let it come to that, by law, private attorneys, private citizen suits in the environmental context, they get the right for the reimbursement of all of their attorney's fees, all of their experts' fees, all of their costs. And I'm not done with the bad news, plus a multiplier. So if they get you, if there's any violation whatsoever, and there are federal cases that say, if a citizen plaintiff has alleged, let's just use kind of like a percentage. If they've alleged 100 violations and they've lost on 99 of them, but they've won on one of them, then they're considered to be the prevailing party and they get their attorney's fees and costs. And the multiplier can be 2 times or more of the entire value of their attorney's fees and costs. That's That's, you know, it may not be back breaking for larger warehouse owners and operators, but it is not an insignificant amount of money. And once you've been found with a violation, they will always be haunting you. So, got to get into compliance now. Oh, Terry, I don't have a violation. I don't have a warehouse that's 100,000 square feet. Well, you know what? That's also nebulous in the definition. So I have clients that told me, I don't have to worry about it, Terry. And I said, do you have a manufacturing facility in the same building, which also has a storage area, which could be deemed a warehouse? And in total, does all of that add up to 100,000 square feet? Yeah, we think so. I said, well, then technically you could fall under the definition, because you're making something on one end of the building and then moving it to store it on the other end of the building, and the other end of the building, a truck comes and you load the product. That's a warehouse. So you've got to be careful with that. And you've got to get into compliance now, because it doesn't get better if it falls under the ambit of federal law. I thank you all for listening. I greatly appreciate this opportunity. And if you have any questions, add them to your chat, or you'll have my contact information and you can reach out and talk to me. And if you're ever interested in learning more about environmental law, I have a podcast, Essential Environmental, which you can access under the firm's website by typing in my name, or it's available under Apple and Spotify. Just type in Essential Environmental. I greatly appreciate your time. And now we're going to transition to my longtime partner, Theodore Bacon.
Good afternoon, everybody, or good morning if you're on the West Coast. I, as said, been involved in employment litigation for over 40 years, and I wanted to talk to you today really about some of the brand new laws in California regarding employment. These are particular areas that I think that anybody that does work in California needs to be concerned about. And much like what Terry has talked about with the environmental, California is stretching its arm out across the country in some of these areas. Next slide, please. So the first thing we're going to talk about is whistleblower law. Whistleblower law in California is a greatly expanding issue. It basically is it exists to protect employees who identify and report violations of the law, and understand that violations of law is very broadly interpreted. And reporting means that you report it to somebody who can do something about it. So if an employee reports to his supervisor that, hey, I'm not getting paid proper overtime, overtime is a law. And if they report that to it and it's not dealt with, that can give rise to a whistleblower claim. It's very, very broad. And for what I'm going to tell you in a little while, there's a lot of reasons why the use of it is expanding. Next slide, please. They're dangerous because this is what the statute says. It says that anybody shall not retaliate an employee for disclosing information to a government agency or law enforcement agency. And here's the key: to a person with authority over the employee, or another employee who has the authority to investigate, discover, or correct the problem. So it's not just that they have to whistleblow to the EEOC or the Civil Rights Division in California or anything like that. They can just report it to their supervisor, who would have an obligation then under the law to report it and to deal with it. It can also be obviously testifying or anything like that. So it's a pretty broad scope in terms of what is defined as a whistleblower. Next slide, please. But here's the real problem is that once it's been demonstrated that an activity was a contributing factor in the prohibited action by the employee, you have to prove that you have a legitimate reason by clear and convincing evidence. Let's break that down a little bit. So you've got somebody that says, hey, I didn't get paid my overtime, and the employer looks into it, rightly or wrongly determines that the overtime was not due. A month down the road, decides that it's going to do a layoff and terminates the employee. We are now in a situation where under normal discrimination laws, if this person was basically complained about sexual harassment or something, there would be the employee just has to show, hey, I was in a protected class. I was a person of color and I got terminated because of my race. And now the employer could come back and they have a burden of, it's more likely than not. Employer comes back and says, well, we terminated you because you were stealing from the company. You were clocking in and then not coming to work for half an hour later. That's the reason we terminated you. And they would only have to establish that by, again, ponderance of the evidence, just basically a little more likely than not. In whistleblower cases, it's different. Once the employee shows that, hey, the part of a significant factor, not the whole factor, not the whole reason, just a contributing factor was the whistleblowing, then it's now goes to the employer to prove the legitimate reason by clear and convincing evidence. Next slide. What does that mean? Clear and convincing. It's not more likely than not. Again, let's go to the next one, which is beyond the contributing factor. You can win if you could show the employee would have been fired anyway. If I said if you stole money, you might conclude you've been fired anyway, but you've got to do it by clear and convincing evidence. And let's take the next slide and look at what a clear and convincing evidence means. That means that there's a high probability that it's true, more as opposed to something being more likely than not. So because this new standard is involved in whistleblowing, what's happening in California is virtually every case that is employment case in California now puts into this whole clear and convincing standard by alleging a whistleblower claim. They say, oh, I complained that I was being harassed at work and they didn't do anything about it. That's a violation of law. I'm a whistleblower. I complained about not getting a meal period. That's a violation of law. I'm a whistleblower. And they're all doing this so they can get to this where instead of just establishing that you terminated them because they stole money, it's more likely than not they stole money. Now you got to prove that they stole money or did something more likely than not. Not more, a high probability as opposed to more likely than not. It's a much more difficult burden. Next slide. So what are the takeaways? The takeaways are here that you must thoroughly investigate whistleblower claims. You want to establish basically that when somebody has made any kind of a claim of a violation of law, that the company has taken it seriously, has investigated it, has determined that whether the corrective action needs to be taken or not. All this has to be very well documented in terms of the investigative process. There also is in the state of California, the Civil Rights Division puts out basically a guideline of how to do investigations, and it will tell you all the things that investigators must do. You can do it internally for smaller cases. You can hire lawyers to do it. You can hire outside firms to do the investigation, but it's very important to have this kind of claim investigated. And I think it depends a little bit on the type of the claim. If it's a very simple, hey, I worked 9 hours and I only got paid at regular rate for the extra hour, you may be able to do that just internally. But I had another case where the whistleblowing claim was that they were a aircraft repair facility, and the allegation was that they were skipping steps required by the FAA before certifying parts as airworthy. That's a very serious claim because if the parts are not airworthy and they're put into planes, that's a very serious claim. That's something that needs to be probably investigated by an outside third-party investigator and very detailed documentation. And so then if this employee has made a claim and you want to terminate, you have to have that same kind of very clear process establishing the basis for termination. That's something you really probably want to have reviewed by an employment lawyer before you pull the trigger on a termination of somebody that is engaged in whistleblowing activities. And the reason being that this clear and convincing standard, you've got to get a jury to look at that and say, wow, they did a thorough job in terms of investigating. I've had other cases where the paperwork in terms of it was specifically one where the employee was accused of clocking in before they actually started work. And there were video cameras that could have really established where the employee was at certain point in time, and fingerprint in terms of their time cards, how they input their time. The employer did an investigation, but didn't really look at all of the video, didn't really check the computer records to confirm thoroughly that the employees were violating the time clock policies. And that creates a little bit of an iffiness, probably enough to establish that it might have won on a more likely than not, but probably not on a clear and convincing standard. So investigating the whistleblower claims themselves and making sure that you have a very, very solid basis and documentation for your basis for termination. And the last thing I'll say in minimizing the claim is think about having some time pass. Cases where the employee makes a whistleblowing claim and a week later they are terminated, that temporal proximity between the time that they make the claim and the time they get terminated, it's a very, very bad fact, very difficult. It's much more better if you have the whistleblower claim, you investigate it, you do whatever corrective action states, and then if that person is going to be terminated, there is a period of time where if their performance is bad, they're looked at and reviewed and thoroughly examined before you ever get to the point of terminating them. The more time that passes between the resolution of the whistleblower claim and the time the employee is terminated, the better. Next slide, please. Next, we're going to go into what I think anybody in most any other state would call the overreaching nature of the Golden State. In California, it's always been very clear that restrictive covenants are void in California, and so that if you have an agreement in California that says with your employee, hey, if you leave my company, you cannot go work for my competitor for at least a year. That's what we all deem as a typical non-compete agreement. Those are illegal in California. The only time you can have a non-compete is if you actually sell somebody or buy somebody's company. I'm ABC company. I buy my competitor XYZ. I can prohibit XYZ from competing with me for 5 years because what's the point of me paying $2 million for this company when XYZ can the next day go out and set up shop across the street and take back all his customers. So other than in the sale of a business or a dissolution of a partnership, non-competes are completely void. Non-solicits are completely void too. Non-solicits are, hey, you employee, you can go work for my competitor, but you can't call on any of the people that you worked with while you were at my company. Those are also void in California, except of course, in the connection with the sale of a business. Non-interference and non-interference are basically, hey, if you leave my company, you can't hire any of my employees. Those are still enforceable in California, and that's always been the law in California. But the new law, BP Business and Professions Code 16600.5 says, even if you have your company is in, for example, Ohio, and from Ohio you say, hey, all employees in California, I've got 3 of you. You all agree that Ohio law is going to apply to your work in California, and Ohio allows for covenants not to compete or non-solicits. And so under Ohio law, you are bound to this non-solicitation or non-compete agreement. California now says, our law in our state, the fundamental policy is freedom of movement of employees. So even if you agree with your employer that Ohio law is going to apply, even if your employer is in Ohio, that's not going to fly in California. That law will not be enforced in California. And there is a lot in terms of the conflicts of law provisions that basically say because California makes this their fundamental policy, that's enforceable. You still can tie it into trade secrets. You can still say to your employee, look, you can't use our confidential customer list or our confidential secrets or how we do things in order to compete with us, but you can't have just one that says you flat out can't compete or can't solicit with us. So that's an important thing in under California law, even if out-of-state laws would allow the enforcement, not enforceable in California. Next slide. But beyond that, just this year, California has added another provision that basically says, and if you company that is in Ohio has an agreement with your employee that you did years ago, you know, maybe you drew up this agreement in 2020, and the agreement has a non-solicitation clause or a non-compete clause in it. If you have that agreement with your employee, you now have an affirmative obligation to every employee that's existing with you now, or anybody that was terminated on or after 1/1/2022, to send them a letter and tell them, hey, that covenant not to compete or that non-compete clause that we had with you that we did in 2020, that's no longer valid. You're supposed to have done that by the 14th of February, but you can still cure that by taking care of that. So it's next slide, please. It's imperative that you do a search of your employee files to see if there's any of these non-existing of these non-compete agreements, and to provide proper notice to the employees that look, those clauses are no longer enforceable, and keep a documentation and proof of that you did notice them. You should, of course, always consult any legal counsel before seeking to enforce any kind of restrictive covenant. And I would include on that even non-interference agreements, agreements that basically say, hey, employee, you can't come in here and hire away any of our employees. So again, the reach of California is going out beyond the state lines to make sure that nobody else can come into California and prevent their employees from competing with their former employers. All right, not on to the next topic. Next slide. Arbitration agreements. And arbitration agreements in California are one of the most critical and important weapons that you can have in employment law. The Los Angeles Superior Court is notorious for astronomical verdicts. Discrimination cases, age discrimination cases where the person is fired after 20 years of work and obtains $3 or $4 million in emotional distress damages and tens of millions of dollars in punitive damages. A lot of those are cut down on appeal, but cutting it down to 25 million to 10 million is still an absolutely crazy result. Why does that happen? It happens because you've got very liberal juries in California in some areas, basically primarily Los Angeles, San Francisco, and Alameda counties. And these verdicts are full of employees. A lot of these employees have not had great experiences with their employer, and they look at this as a way to get back at their former employers as well as everybody else. It's just a fact of life. But what an arbitration agreement does is pulls that out of the jury system into an arbitration where you can basically control who's going to be the judge, take it away from 12 employees and put it in the hands of one retired judge, have some say in which judge is going to be hearing the case, and that really just helps prevent runaway verdicts. Next slide, please. So what are the pros and cons of arbitration agreements? The pros are that there's no jury, and you're not going to have those 12 former employees and maybe one or two employers. You get to select the trier of fact. You have a say in who the judge is going to be. You don't unilaterally get to pick it, but at least in most of the processes, there's a strike and select and ranking provision that happens so that you get to work with a judge that is going to be fair. You have longer delays, and you have longer days for trial and no delays. Often I will go into a superior court in California or a federal court, and the judge will say, okay, you can try your case from 10 to 12, then we're going to break for lunch until 1:30. You can come back from 1:30 to 4:30. So you end up getting maybe 5 hours of trial in a day. In a arbitration, you can crank out 8 hours. It's much more efficient, and you can know that when your arbitration's date set, you're going to go there. Oftentimes you go to court, and when you go to court, you may come to be ready for trial, and the judge says, no, I've got another matter I've got to handle. Come back in 3 months and do that over and over again. The biggest pro is you can eliminate class actions, especially in the wage and hour area. The Viking River case that just came down recently upheld the waiver of class actions. So you can say to all your employees, basically, look, you signed this arbitration agreement, you're agreeing that you're not going to be part of or file an action, a class action. You can have your individual claim handled, and an individual claim will be handled by arbitration, but you're not going to be part of a class. And that is a huge weapon to eliminate class actions. The cons of the arbitration agreement, it is a higher cost in terms of, I'm not sure if it's a higher cost overall, because the cost of a jury case and civil case, you may pay more in attorney's fees, but on the con side, you got to pay the arbitrator's fees, 100% of them, if you're the employer. It can be $50,000 or more. Plus, you still got to pay your attorney. You don't get an appeal. If you get a bad decision from an arbitrator, you're stuck with it. There's no way to appeal. It also doesn't help you on PAGA representative actions. And essentially what Terry said, those are available in the environmental law. They're also widely used in employment cases. Those are basically cases where the attorney general would have a right to say, hey, you're not paying overtime to your employees. I'm going to make you pay your employees overtime, and I'm going to penalize you $100 for every paycheck that was invalid for every employee. PAGA is basically somebody acting on behalf of the attorney general to enforce those laws, and they get a little bit of a bump of the fee. Most of the fees go to the state of California, but again, like Terry said, there are attorney's fees and provisions with this, and so although it is, the acronym is the Private Attorney General's Act, I tend to refer to as the Plaintiff's Attorney's Goldmine Act, because it is basically a way for the money goes to the state, very little goes to the employees, and a large amount of money goes to the plaintiff's attorneys. So they just find somebody, file a claim, say, hey, it's going to be $1 million to settle this PAGA case. If I win on everything, give me 300 grand and I'll go away. They take 100 grand and they move from there. So it doesn't help you with those, but it does help you with class actions. There's other ways to fight PAGA cases. Next slide, please. The new law that it's very unfortunate and important is that it used to be that when you filed a petition to compel arbitration, that and the judge says, no, I'm not going to compel arbitration, I'm going to deny that motion. You could file an appeal, and that would stay the civil action, meaning while the appeal is pending, which can be a year or more, the civil action cannot go forward. No discovery, no trial, no anything. Now the law has changed where the court has the discretion. The same judge that decided, I'm not going to grant your motion to compel, can decide whether you have a right to stay the civil action in the meantime. And the problem, of course, is a judge who's denied your motion to compel is probably not inclined to stay the case, because that would basically be them saying, oh yeah, I won't let this case go forward so that you can have a chance to show that I was wrong. And so it's unlikely that judge who have denied your motion to compel is going to stay the case. And then the fact is that by the time the appeal is decided, your whole case could have been tried. You could have you've incurred all the cost of discovery. You might even have a verdict in or a decision. And so it really just guts the whole motion to compel arbitration. So next slide. So what do you do about all this? First of all, if you're going to employ arbitration agreements in California, make sure that it's enforceable. There is A lot of times people put arbitration agreements into the middle of their employee handbook or as a part of a bunch of documents. It's really important that it's a standalone agreement. It should be an agreement that is basically put in front of the employee at the time of onboarding, a separate document, and it should be compliant with the Armendariz case, which is a California Supreme Court case. And it basically says that the arbitration agreement should have fair and reasonable discovery. I mean, you can't say something like, oh, you can only ask 10 questions and you can only demand 5 documents and only take 1 deposition. Usually it is just best to say the discovery can go per the regular California law. And so that it's wide open discovery. Then nobody can come back and say that your discovery is unreasonable. You can't shorten any time to file the claims. You can't say if you don't file for arbitration within 1 year and the normal statute of limitations is 2 years, if you shorten your claims like that, it's not going to be enforceable. The employer has to pay all of the arbitrator's fees. And so again, that's very costly, but it is part of it. And the other thing is you can't prohibit the plaintiff from getting anything, including the right to recover attorney's fees if they win the case. So you want it to be standalone. You want to make sure that it's compliant with Armendariz. I'll say just as an aside, you don't want to have it drafted by AI. There's a couple of times where they've asked AI draft a arbitration agreement under California law. And it was the document that came out was patently unenforceable under Armendariz. The other thing is, in terms of these employment agreements, give everybody a reasonable chance to consider the employees. You know, you don't have to do this just for employees that are new employees that are coming in. You can have your entire employment force right now, tomorrow. You can say, look, new policy, we're all going to sign arbitration agreements. And you can basically say that, look, if you want to continue working here, you're going to have to sign this arbitration agreement. But what you don't want to do is say, oh, you're going to have to sign we're going to put in this arbitration policy. It's our new policy going forward, but you have to sign today. Give them a couple of weeks to look at it. Tell them, you don't have to change the agreement. You don't have to amend it, but you give them a couple of weeks so they can take it to a lawyer and encourage them to do so. Take it to a lawyer if you want, look at it, understand what it means, understand what rights you're giving up, understand what rights you're getting. I recommend even having, basically, if you're going to roll this out, you send all the employees a copy of the arbitration agreement. You put out a letter that basically says, hey, take your time to discuss it with your lawyer or counselor or read it through. And you have actually town hall meetings where you set up a time where you basically present to everybody and do a Q&A where they can ask questions about the arbitration agreement. What does it mean? What does it do? And then at the end of that period, say, okay, we need you all to sign it, but understand also, if you don't sign it and you continue to work for us, your continuing to work for us will be deemed an acceptance of the arbitration agreement. That is something that is enforceable under California law. You don't actually have to have a signature. You can enforce an arbitration agreement. But the key in that is you can't say, here's the arbitration agreement, it's in effect tomorrow, and if you come into work tomorrow, you're stuck with it. You need to be able to go to the judge and basically say, when you're trying to enforce this arbitration agreement, goes back to the prior screen, you don't want to have that motion to compel the arbitration denied, because your right to appeal it is shaky at best now. So you want to make sure that when you go into the court, when you file your motion, you can say, look, this is what we do. We sit down with the employees, we give them the agreement. Here's the date and the time that we gave them the agreement. Here's the email that shows that everybody got the agreement, or here's the day we handed them all out. Here's the letter that went with them that explained it all to them. It explained what their rights were under the arbitration agreements. Here's the town meetings that we had. Here's the sign-in sheet that showed that they attended this meeting. Here's the kind of script of what we went over at the meeting where we discussed the arbitration agreement. Here's the notice to them that if they don't sign after this date, that they're going to be bound by it. Have all of those procedures in place so that you can defeat the arguments that the employee didn't understand what they were doing. And if you've got employees that English is their second language, take the time to have it translated into another language. It's really important. You're not technically obligated to do that unless you have 10% of your employees that are English is their second language. But frankly, it's not that big a deal now to have those agreements translated. And if you have employees that speak it, that English is not their first language, translate it into Mandarin or Spanish or whatever is necessary to do it. But you want to have that line so that your whole department can show exactly what happened in terms of getting these. But getting those arbitration agreements is very important in California. With that, I'm going to send it back over for questioning. And I thank you so much for your time, and I look forward to answering any further questions.
All right, Ted, thank you very much. Terry, thank you. As Ted mentioned, we're opening up the floor to some Q&A. Please submit your questions in the through the chat box at the bottom of your Zoom screen. We do have our first question here. Let me see here. We got. I was wondering, Terry, you had mentioned some like types of equipment that in like the different scopes, scope 1, scope 2, and we had listed off some examples of equipment. Is there something that people that can reference, to find out what those types of equipment's an actual, like a complete list?
There are lots of sources for that, including you can do a general Google search for scope 1 and scope 2 equipment. But the California rule, Senate Bill 253, does state that reporting of Class 3 emissions should be consistent with the international GHG protocol. So the GHG protocol will also have information in there about scope 1 and scope 2 obligations. But
okay, all right. Let's see. We got a question here. So should all employers have employees sign arbitration agreements?
Well, I think that really just depends upon, if you don't have any employees in California, then it's not as a black or white question in terms of doing it. But by and large, overwhelmingly, Defense Counsel and Management Counsel in California is going to advise that you should have an arbitration agreement assigned by California employees. And even if you have 2 or 3 employees in California, it doesn't take a lot to, a single age discrimination case can have tremendous exposure. And having that case tried in front of a retired Superior Court judge instead of a jury is going to make a huge difference. So I would say if you have anybody in California, you should do it. There's some other states that I think it's important to as well, Massachusetts, New Jersey, or New York. But other than that, you need probably to consult other local counsel in the other states to determine whether an arbitration agreement is the best. Because in other states, it doesn't really make as much difference because you don't have these crazy runaway juries that you do in California.
Okay. Thanks, Ted. I have a request here, if maybe we could go back to slide, it's either 2 or 3, the SB 261 slide. And there's not a question yet, but maybe reviewing that slide again will prompt some questions. So we'll let that kind of
Simmer.
sit
Let it
there.
simmer.
I'm sorry, I have another question. What steps should be taken to be sure termination of a whistleblower will stand up in court?
Well, as I indicated, I think one of the key points of the whistleblower is that you've got to prove your legitimate business reason for terminating is by clear and convincing evidence. So similar to what I said under the when I was talking about arbitration agreements and having your proof already, I think one of the best starting points is there's a document that is put out by the Civil Rights Division of California. It's kind of like their EEOC. And this says how to do a proper investigation. And it says things like interview the people that are involved. Don't require them to put things in writing, but if they want to, it's great. Keep all your handwritten notes. A lot of times investigations are done and people do handwritten notes, then they summarize those and they discard the handwritten notes. The California Civil Rights Division encourages you to keep those notes. And I can guarantee you, when you're trying a case, if you're up there and your HR manager does not have those handwritten notes, that first thing the plaintiff's lawyer is going to do is put up this, oh, this is the way the California Rights Division in California says you should do it. You didn't do that. You failed to do take reasonable steps to prevent harassment from occurring. And then they're off to the races in terms of winning the case. So documenting everything that you do, interviewing the relevant people, and then coming to a decision and being sure that that decision is conveyed both to the accused or to the employer and to everybody else. And in this case, when you're terminating, another critical rule in California is if you're terminating an employee for cause, you must give them an opportunity to tell their side of the story, even if it's you think it's completely ridiculous that they would have any kind of explanation. Something like, well, we have you on video. You worked as a bartender or at a restaurant. We have you in the video grabbing a stack of hundreds out of the cash register drawer and stuffing them into your pocket. You still have to show that video to the employee, ask them to confirm or deny that they stole the money before you terminate them. You can't just terminate them off the cuff because they may have an ability to say something like, hey, that looks like me in the video, but that's not really me, and explain it away. Is it likely? No. Do you have to listen to them and agree that they're correct? No, you don't have to. You can say, no, we're pretty sure that's you. In good faith, we believe that's you, and we're going to continue with our decision to terminate. But you have to give them that chance. So those kind of things are very important. Documentation, getting the employee's side of the story, just making very, very clear. And what you want to do, really, at the end of the day, whether it's an arbitration or whether it's a jury trial, you want the people that are reviewing your case, the judge or the jury, to look at it and say, wow, that was fair. That's how I would want to be treated if I was an employee. I think they gave the person a fair shot. That's what you're looking for. And if you can establish that, you're going to have a lot better chance of winning at trial and establishing that the termination was legitimate by clear and convincing evidence.
Okay, thank you. We have one more question, but for the attendee that did request us to shift the slide, if you have a question, go ahead and submit it. We could get anything that you're curious about answered here. Question 3, what are the most prevalent types of employment law actions in California today?
That's interesting. It's a good question. I mentioned one of them, which is the whistleblower cases. Again, what they're doing is any kind of violation. It used to be you just would have a sexual harassment case, and it would be I was sexually harassed, or you failed to prevent harassment from occurring, and that would be the sole basis of the claim. Now you generally get a whistleblower claim added onto that as well. But despite all of the Me Too movement and a lot of the the discussions regarding sexual harassment, by and large, the most prevalent kind of cases in California are disability discrimination cases, cases where the employers are alleged to not have accommodated a disabled employee or didn't engage in the process of talking to them about their disability and trying to find a way to accommodating them, or terminating them because allegedly they were disabled. They're very difficult cases. Again, all I can say in connection with that is it's very critical for your people to be trained to identify a potential disability and get that over to HR. And in short, that's a situation where if you're doing a performance review and somebody's been a good worker for 5 years and all of a sudden they're really a poor worker, you need to ask, is there something happening mentally or physically that's affecting your ability to work? And if they say no, you're great. You've crossed that off the list. But if they say yes, then that triggers you getting it over to HR to do the interactive process and accommodation discussion. And that you want to have that discussion while they're still employed. You don't want to learn about the fact that they had a disability a year later when they file their claim, because then there's nothing you can do to fix it. So disability claims, again, are just the biggest thing in California. And I think that's probably fairly prevalent nationwide.
Okay, very good, Ted. It looks like that may be our last question. Can you maybe let's go down to the closing slide just so that everybody can see the contact information for Ted and Terry. If there are no more questions, maybe any closing comments from either of you, Ted or Terry?
Well, I want to thank you again for the opportunity. It's greatly appreciated.
Bet. We
Likewise.
appreciate you coming in and speaking to this pretty important topic. Ted, do you have anything?
No, just appreciate the opportunity to get you advised of how things are, employment laws here in the Wild Wild West, and wish you all luck with complying with all these crazy things that Terry and I talked about.
Very good. Well, Terry, Ted, I want to thank you, and thank you to all of our attendees for joining us today. As we mentioned at the outset, we will follow up with the presentation materials, as well as Terry and Ted's contact information, the PMA California district information, and we'll also include a survey to get your feedback on today's presentation and input into future programs. So with that, have a great rest of your day, and in the spirit of Ron Burgundy, you stay classy, California. Take care.
Thank you all. Take care.
Take care. Bye-bye.